Considering he was black, it's gotta be number 5, I guess.
See through you, see your true colors.
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti. Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Liedaho criminal cases. One in particular. We're not going to talk about the Bryan Kohberger case in this one, even though what I am talking about is in reference to the Bryan Kohberger case. Because in the videos that I did yesterday, one of them, I alluded to the fact that I didn't think this thing was over, that there were things behind the scenes and we should see some movement in it soon. And as I made that video, I was reading my comments, and then I noticed one of my old comrades, A.R. Hayes, left me a comment. And I appreciate A.R. Hayes, love the dude. I know he's not doing well right now with his health, and he's in our prayers. And now, one thing about A.R. though, well, he's pessimistic. And he went on to put in the comment that, well, yeah, but all of that takes 20 to 30 years on average if the Innocence Project gets involved, and there's basically no hope. And while I appreciate his opinion and his pessimism, me, on the other hand, I'm a glass half full type of guy. I'm very optimistic on things. So I try to connect the dots where things are relative. And in one of the videos that I did yesterday, I talked about Miss Elisa Massoth and her record as it relates to post-conviction relief wins. She's exonerated 2 people. So I dove in a little bit deeper and thought, well, let's just take a look at some of this post-conviction relief. And one of the cases that she won was very interesting. And it also shows the violent nature of some of the criminals up there in Idaho. But it also shows the way that the authorities and the judicial system up there in Liedaho works as well. The dirty tricks that they pull, and there's a lot of correlation between cases. So what I'm going to do in this video is talk about the main case that Miss Massoth actually got relief for her client. How long it took, give you the history of it, and show you the violent nature of it. And we're going to talk about that. But first, let me get you familiar with what happened in this case, and then we'll talk about some of the things that I want to mention as it relates to the judicial system up there in Idaho and what they do, and also the type of criminal that would be involved in a case such as the Idaho 4. So let's just get right into it. This is going to be the case of John Wurdemann. Background and history. When we go to the written decision by the Supreme Court of Idaho in upholding the post-conviction relief for John David Wurdemann, we learn some of the details about the case in which he was charged. The initial case stems from an arrest in 2002 where Wurdemann was convicted on 7 felony counts related to the June 2000 attack of Linda LeBrain. The Court of Appeals described the attack as follows. The crimes that gave rise to this prosecution occurred in the early morning hours of June 15, 2000, when 4 people in another vehicle forced Linda LeBrain to stop her car on Interstate 84 in Canyon County, demanded money and drugs from her, commandeered her vehicle, and drove her to a dark field along a country road. There, the foursome took LeBrain's money, credit cards, and belongings, stabbed her repeatedly, slit her throat, hit her in the head with a baseball bat, slashed her shoulder, set her car on fire, and left her to die. Those are the facts of the case. And John Wurdemann was one of the 4 arrested for this crime. Also arrested was Wurdemann's brother. And the state's evidence against Wurdemann largely consisted of testimony from his brother and testimony from the eyewitness identification of Miss LeBrain. Following the history and background of the case, in 2006, Wurdemann's direct appeal was denied by the Court of Appeals. In 2011, Wurdemann was denied post-conviction relief, and he appealed that denial. In July of 2012, while his post-conviction appeal was pending, Wurdemann filed an Idaho Rule of Civil Procedure 60B motion, relief from a judgment or order. The district court granted the motion, and in March 2015 held a new evidentiary hearing on whether Wurdemann was denied his Sixth Amendment right to effective assistance of counsel. Following the evidentiary hearing, the district court ruled that Wurdemann was denied his right to the effective assistance of counsel and vacated his convictions. The state appeals the ruling on post-conviction relief. The Supreme Court of Idaho affirmed the ruling of post-conviction relief and released Wurdemann from custody in 2015. This was all due to his new attorney who filed the 60B motion, and that was Elisa Massoth, attorney Idaho. You may be familiar with her, who represented Bryan Kohberger. Now, what really got the ball rolling for Miss Massoth to step in and get involved with this case was not Wurdemann's account of what happened, but the injustice that went on with the other person that was arrested and convicted of being part of this crime, and the work of the Innocence Project in proving her innocence and the media attention surrounding it. Let's review that case first, then we'll come back to the Wurdemann case. Sarah Pierce. Almost 2 years had passed since the robbery and assault on LeBrain when a young lady calls and provides law enforcement with a tip suggesting that her ex-boyfriend may have been one of the assailants responsible for the attack. That was Kenneth Wurdemann, John's 2-year older brother. Kenneth quickly made a deal with law enforcement for a reduced sentence of 12 years to implicate his brother, John Wurdemann, in the crime. And although not implicated by Kenneth, investigators believed another man, 26-year-old Jeremy Sanchez, who was wanted for 3 other violent attacks that year, to be the third assailant, but none of the 3 would identify the female assailant with them. But investigators believed they got lucky. They canvassed nearby jails, as they so often do, and found an informant who said he once heard a young woman in a drug hangout talk about stabbing someone. That young woman ran with Jeremy Sanchez, and here she was. Her name, Sarah Pierce. But at this time, she was 19. She had kicked a drug habit and joined the Job Corps. When detectives arrested her, she was not Hispanic, and she was 5'6", unlike the description that was given by LeBrain of a Hispanic young lady about 5 feet tall and very attractive. Also, Pierce wasn't very attractive at all, some may say. But it didn't stop detectives from finding some corroborating evidence and arresting her. The evidence they found to corroborate the arrest was an eyewitness account from a gentleman who had seen the four at a rest stop shortly before the crime, eyewitness accounts from two men at a local hotel where the four had checked in after the crime, and finally from a photo lineup that Miss LeBrain herself had picked Pierce out of in order to gain the conviction. Sarah Pierce was convicted and sentenced to 15 years to life in the penitentiary. Jeremy Sanchez was also convicted and he was sentenced to life in the penitentiary. Kenneth Wurdemann, who worked with authorities on the case, received a reduced sentence of 12 years. And his brother, John Wurdemann, also received a sentence of life in the penitentiary. Now, over the years, Pierce's mother, who vehemently believed in her daughter's innocence, never lost hope that justice would be served in her daughter's case. She enlisted the help of the Idaho Innocence Project, and things ensued from there. Believing in her innocence, her mother enlisted the help of the Innocence Project of Idaho. They began independently investigating the case. And considering the entire case against Pierce started from a jailhouse snitch making a phone call and implicating her, it was the same format, although this time it was an inmate in the Idaho prison with a conscience that knew something about the true events that happened and the fact that they had the wrong person charged with that crime. He contacted the Innocence Project and things started to snowball from there. This family was willing to testify after all these years that the person that they had seen come to their house after that horrific event and clean the blood off of their clothes was not Pierce, but a young lady that actually matched the description of the assailant. 5 foot tall, young, attractive, and of Hispanic descent. From there, it was locating the other witnesses in the case that testified against Pierce and seeing what they had to say. The original witnesses that testified against Pierce in her original trial quickly recanted their testimony, indicating that although they may have meant well, they were literally clinically stupid and went along with anything law enforcement wanted them to go along with simply because they are literally that dumb. At least they did the right thing in the end. Now, like happens so often in cases like this, once the officials heard of the new evidence that the Innocence Project was going to bring on her behalf, instead of doing the right thing and having a trial and exonerating her and then arresting the real criminal, instead they chose to make her a deal. Either continue fighting and maybe years earn her exoneration, or they would release her immediately if she continued to admit to the crime and live the rest of her life as if she was the one that committed the crime and continue to be a felon for the rest of her life. She took the deal to get out of prison. Now, a lingering question is, why did that family who had that information that could have exonerated her years earlier hold on to it and never tell the authorities until they were searched out by the Innocence Project? It's the same story, different day. The one that had sent the tip into the Innocence Project with the information, his name was Romeo. He was in prison at the time, and he told the Innocence Project to go talk to his mother. But his mother would not tell him exactly what happened for a long time. Why?
Romeo's mother, who would only say so much, saying anything more or going to law enforcement, Mrs. Rivera said, but put the entire family in danger. After all, she said the family had run-ins with the law if they were seen as snitches and if any of the boys were in jail. The consequences could be fatal.
Now, with all of the media attention at the Pierce case and the possible wrongdoings in that one, it inspired attorney Elisa Massoth to work on behalf of John Wurdemann and to take a look at his case and see if there was anything nefarious about it as well. And what she found was something in particular that proves ineffective assistance of counsel. And it related to how he was actually identified as a suspect in the case. It came down to an actual lineup of possible assailants with John as one of them and Miss LeBrain picking him out of that lineup. It was the format of the lineup that was egregious. So when we go back to the post-conviction relief ruling by the Supreme Court on John Wurdemann, it says, following the grant of Wurdemann's IRCP 60B motion, the district court held an evidentiary hearing on the issue of whether Wurdemann was denied effective assistance of counsel in violation of his Sixth Amendment rights. The district court found that Wurdemann was denied his right to effective assistance of counsel because trial counsel failed to properly challenge LeBrain's eyewitness identification of Wurdemann at trial. Ineffective assistance of counsel requires a finding that 1, the attorney's performance was deficient, and 2, the defendant was prejudiced by the deficiency. The district court ruled that trial counsel's failure to consult with an expert witness and provide a proper challenge to the lineups and identifications fell below an objective standard of reasonableness. Specifically, the district court found that counsel's failure to consult an expert on eyewitness identification and counsel's failure to challenge the eyewitness's identifications in pretrial motions was so deficient that this conduct denied Wurdemann a proper functioning adversarial system. Whether the motion to suppress, had it been made, should have been granted. That's always key. Would it have been granted if they had made it? Due process requires the exclusion of identification evidence if police suggestiveness created a substantial risk of mistaken identification, except where the reliability of the identification is sufficient to outweigh the corrupting effect of the suggestive identification. In considering whether an identification is reliable, this court employs the Manson-Biggers balancing test, which looks at the opportunity of the witness to view the criminal at the time of the crime, the witness' degree of attention, the accuracy of the witness' prior description of the criminal, the level of certainty demonstrated at the identification, and finally, the length of time between the crime and the identification. In the present case, the identification procedures used by police were clearly improperly suggestive. In her description of the attacker, LeBrain described her attacker as being very, very tall and thin. His hair was greasy. It was long, dark. He looked like a Hispanic or Native American man, and he was very tall. He was thin, and his face was it looked like it had really bad rash on it. It was really messed up. His face was really messed up. In addition, LeBrain testified that her attacker spoke in English, and she indicated that her attacker did not have facial hair. In the video lineup in which LeBrain identified Wurdemann, it consisted of 6 men. Wurdemann was placed in the center. He was noticeably the tallest participant. He was one of only 3 participants who had long hair. Of the other 2 participants who had long hair, both were much shorter than Wurdemann. One did not speak English, and the other had significant facial hair. Thus, Wurdemann was the only participant in the lineup who could be fairly described as being tall, thin, Hispanic, or Native American with dark hair, long, and no facial hair, and able to speak English. As described at the evidentiary hearing by Dr. Reisberg, an expert in witness identification, the video lineup was among the worst video lineups he had ever seen. Having determined the lineup was improperly suggestive, we next turn to the 5-part Manson-Biggers balancing test to analyze the reliability of the identification. And again, that consists of the opportunity to view. The attack on LaBraine took place sometime after 11:30 p.m. It was dark. LaBraine needs glasses to correct her vision. At some point during the attack, her glasses came off. It is unclear whether her glasses came off before the man LaBraine identified as Wurdemann got in her car or later in the attack. However, LaBraine testified that at some point after the man identified as Wurdemann entered the car, he was as close as 3 inches to her, and the dome light of her car was on. Given the proximity of her attacker and the illumination from the dome light, regardless of when she lost her glasses, LaBraine had a relatively good opportunity to view her attacker. Now, I will point out in the footnote here, though, it says, shortly after the attack occurred, LaBraine told officers, after they were in the car, I couldn't see a thing. I'm blind. Kind of reminds me of, I don't know if it was real or not. I was drunk. I couldn't tell if what I saw was even real. Later, however, LaBraine testified that she did not lose her glasses until later on in the attack. I was under the impression that your glasses were taken off at the first place they stopped you on the freeway. Answer: no, that's not true. They were taken off when they came back the second time. Degree of attention. LaBraine testified that she had been smoking Mary Jane immediately prior to her attack. She also testified that she was loaded, but that she had only smoked 2 joints and that she was not impaired. She's loaded, but she only smoked 2 joints and she was not impaired. Okay. LaBraine stated she memorized what her attacker looked like and that she had ample opportunity to look at each of them in the face. Given the amount of time involved in the attack, the severity of the injuries LaBraine sustained, and LaBraine's testimony that she focused on her attackers' faces and memorized them, it is likely that despite being loaded, her degree of attention was high, even if her faculties were affected by the Mary Jane use. The accuracy of the description. Shortly after the attack occurred, LaBraine provided a description of her attacker to police and helped produce a composite sketch of her attacker. In her description, she described her attacker as being Native American or Hispanic, tall, thin, with long hair, and a pockmarked or rash-covered face. The height and pockmarks were the most significant features to LaBraine. Wurdemann is Native American, tall, thin, and has long dark hair. However, in the video lineup, his face is clear of pockmarks or a rash, and a photo taken of Wurdemann approximately 3 months after the attack shows him as only having 1 or 2 blemishes on his face. This is not to say, however, that Wurdemann did not have a rash or other markings on his face at the time of the attack that later cleared up. Thus, despite the current absence of a rash or pockmarks, it appears that Wurdemann fairly meets the description LaBraine gave of her attacker. Then there's the level of certainty. LaBraine testified at trial that she was certain that Wurdemann was her attacker and that she identified him without hesitation during the lineup. However, there were no records kept as to her reaction during the lineup or her comments regarding Wurdemann's identification at the time of the lineup. Additionally, LaBraine identified other men and at least 3 other photo lineups as being the attacker she later identified as Wurdemann. In all 3 of those lineups, LaBraine picked out a person and indicated with some level of certainty that the person she picked was her attacker. None of the people LaBraine picked out in the photo lineups were her attacker, and none of them were Wurdemann. LaBraine's explanation as to why she picked the other men in the photo lineups was that she thought she had to pick someone out of the lineup. However, there is no indication that LaBraine felt any different about the lineup with Wurdemann. Indeed, she testified that she felt like she had to pick someone out of the video lineup, just like she had in the other lineups. Furthermore, Wayne Christie, an officer involved in the investigation of the attack, stated in his affidavit that another man, Salvador Nez, more closely matched the composite drawing of LeBrain's attacker and was a known accomplice of Jeremy Sanchez, who was also convicted of the attack on LeBrain. Good grief. Conclusion. Because the reliability of the identification does not outweigh the suggestiveness of the video lineup in which Wurdemann was identified as LeBrain's attacker, and because the decision not to challenge the lineup was based on inadequate preparation and ignorance of the relevant law, we hold that the trial counsel's failure to challenge the video lineup with a motion to suppress or an objection constituted ineffective assistance of counsel and violated Wurdemann's Sixth Amendment right to the same. The district court's grant of post-conviction relief is affirmed. They went on to release Wurdemann, and to this day, they're still trying to charge him with that crime. But Elisa Massoth made a statement. She said, after all these years, an innocent man finally gets the justice he deserves. Of course, just like in the Pierce case, Idaho man denied access to compensation fund despite overturned conviction. This was in August 22nd of 2024. Apparently, Wurdemann sought to get compensation for those years he spent in prison, wrongfully convicted, but he was denied because John Wurdemann's access to the Innocence Fund after Wurdemann's 2000 conviction was overturned on procedural grounds of ineffective assistance of counsel. Apparently is because it was overturned on procedural grounds of ineffective assistance of counsel after his attorney failed to object to an improper police lineup, and the prosecutor chose not to retry the case because Wurdemann was already serving time for another crime. The state has maintained that Wurdemann is guilty of the crimes. I'm pleased with the ruling from the Idaho Supreme Court related to the Innocence Fund, said Attorney General Raul Labrador. Compensating wrongly convicted individuals based on new evidence demonstrating their innocence is a matter of moral fairness. However, demanding access to the fund for a procedural dismissal for ineffective counsel without presenting exonerating evidence is not the same thing. So it doesn't matter how we screw up and put you in prison, we're never going to admit wrong, and you're never going to live it down. But let's look at a few parallels. Number one, let me point out that up in Idaho, you got some pretty vicious criminals. In this case, you've got 4 thugs that takes a lady that apparently they knew she had drugs and takes her out into a field and stabs her 20 times, slits her throat, sets her car on fire, and she lives. So even thugs that have the propensity to do heinous things like this don't necessarily have the skills and ability to complete the job. Unlike the Idaho 4 case, where you've got 4 healthy individuals that were unalived inside of a few minutes by people that really knew what they were doing. See, it's not just a criminal that knows how to do those things. It's particular criminals that have been taught certain things throughout their life for certain reasons. There's one, certainly in college kids running into unalive people inside of a few minutes on a whim. Certainly isn't a criminology student who's aspiring to be a serial unaliver running in and ninja style unaliving 4 people inside of a few minutes with a knife for no reason whatsoever. That just doesn't happen. That's one. Then you look at all the other things surrounding that case that's applicable to this case, I believe. What is the first thing law enforcement does? Well, they hit the jails and start asking for information from the people that's already in jail. I believe that happened in this case as well. Then you have the ultimate egregiousness. So you had Wurdemann's brother. How did they get to him? Through a tip. His ex-girlfriend called and said, hey, he might have been one of the ones that did it. So what do? They go pick him up and they start hammering him. and then they get his brother's name out of him. And then for him testifying against Sanchez at trial, now Kenneth may have been one of the assailants, but he didn't testify against his brother John at trial. He testified against Sanchez, and that's why he only got 12 years. If you talk, they'll reduce your sentence. But he never testified against his brother John at trial. I think they pulled that information out of him and then slapped him in a lineup like we've demonstrated, where, of course, she's going to pick him, and continued the egregiousness from there because they just wanted convictions in the case, where their detective in the case was clearly saying that, it's probably not him. This other guy that's his accomplice in other crimes much closely resembles the description. But they ignore that because they want to get the easiest conviction. And then, just out of nowhere, they get a name for a young lady from a jailhouse snitch, and then they have no corroborating evidence. They go and they get morons and get them to say, yeah, I think that's the one that I saw, even though she wasn't even the right nationality, height, or anything. And then they convict her and put her in prison. And then once they find out that what they had was absolutely bogus, do they let her out and say, we're sorry, here's some funds? No, they make her a deal. They say, we'll let you out, but you got to continue on with the conviction in this case, but we'll go ahead and let you out because we don't want to be found liable for putting you away all that time and you were the wrong person. It wouldn't be a good look. So what do people do? Well, they've been in prison forever. They want out. They agree to do that. But what does that mean? They never went out and arrested the one that they even at that point knew was guilty of the crime because they already had their conviction, wrongfully so, on the young lady, and going out and arresting the other young lady would end that. And that would cost them financially and would cost them tremendously in the public sphere. And that case hit the public sphere anyways, because Dateline, I guess back when they used to do some real reporting, actually reported on the injustice in that case. But it's amazing how so many things are applicable to the Bryan Kohberger case in the most ridiculous ways possible. Elisa Massoth got the conviction overturned for ineffective assistance of counsel for the Wurdemann case. Why? Because of a suggestive lineup used by law enforcement and ineffective assistance of counsel due to the Manson-Biggers test. Give me a break. The lineup, suggestive. We never even had a lineup in the Kohberger case. We had a girl saying, we think he looked kind of similar to this description, and they showed a picture of her. He didn't even show her a picture. Once he was arrested, they called her, asked her, hey, have you seen the guy that we arrested? Is that him? And she said, well, yeah, I've looked at pictures online. It doesn't ring a bell. They moved forward with it anyway. What is going on in this case? Things that we obviously can't see. You can bet they're going on. Please like and subscribe to this channel. Post your comments, thoughts, criticisms, and until next time, Pavarotti is out.